Who turns down free money?
I will pay 50 cents on the dollar.
I'll take 40 cents on the dollar.
30 cents on the dollar.
20 on the dollar.
10 cents on the dollar.
How about 0 cents on the dollar?
Do you realize how much money he just saved us?
All right, welcome to the second episode of the 50 Cent Dollars podcast, a podcast generally about prediction markets and kind of an offshoot of my Substack, also called 50 Cent Dollars, 50centdollars.com, all spelled out. And generally, I'd like to, when we're trying to think about the future of what might happen with prediction markets, the best way to figure that out is to look at the past and use that to infer patterns and how history doesn't repeat, but it might rhyme. And talking to experts who have been in the game for so long is just, like, I think, a very important exercise. So I'm glad to have a perfect guest here in Mr. Gary DeWaal. He's been a long-time derivatives lawyer, been in the game for decades, was there back when derivatives trading went from the pits to computerized, back when crypto started coming online, and he was an early crypto advocate, crypto lawyer. And now here to have him talk about what he thinks is going to happen with prediction markets and this innovation and the role of regulation in that. And so I just wanted to welcome Gary, and if you could give a bit of background about who you are, what you've done, and yeah.
Great. So thank you for having me on your podcast. It's a pleasure to be here. I'm talking to you live from Estes Park, Colorado, high up in the Rocky Mountains, where this morning was 16 degrees Fahrenheit.
Wow.
And I was told it feels like 6 degrees, but to me, it's a balmy day in Miami. So, what can I tell you? I'm crazy. So as you said, I joined the futures industry in 1982. By background, I had graduated with both a JD and an MBA in 1980. I joined a very big Wall Street law firm that formerly was headed by Richard Nixon, known as Mudrose, Guthrie, and Alexander. I joined as a corporate securities lawyer. Back in the early 1980s, associates who were corporate securities attorneys had a great honor. I got to go to the printers on Hudson Street in New York City every evening from about 6 p.m. till early morning, and proofread documents as they came up the printing press. That's what an associate did at that time. Mm-hmm. I had great people working with me. I had great mentors teaching me, but it probably wasn't what I wanted to do. I had a lunch one day with a gentleman. His name was Richard Fielding. He was the former Associate General Counsel of the Commodity Exchange, Inc., which I had never heard of. Now, I'm a native New Yorker. I was born in Brooklyn, New York, and I've rated the rate.
I can tell.
In the New York metropolitan area. I had an MBA, I had a JD, I had an undergraduate degree in economics. I had never heard of the Commodity Exchange, Inc., and I had never heard of a futures contract until I had lunch with this gentleman, Mr. Fielding. He described the product to me. He talked about this financial instrument, which people don't care if they go up or down because the basic purpose is for hedging, which is to obviously protect against price risk, price movement risk, and I was fascinated. Anyway, 2 days later, he comes into my office at Rose, and he said, Gary, I shouldn't be doing this because here I am, we're fellow employees, but I could tell you were really fascinated by what I was talking about, and I happen to know there's an opening at the Commodity Futures Trading Commission, an agency which I also had never heard.
Still to this day, most people have never heard of until.
And by the way, I can't tell you how many times it's called the Commodities, plural, Futures Trading Commission in the media, which is absolutely wrong. It's Commodity Futures Trading Commission.
Got it.
Anyway, tell me about this job.
Guilty of that. Yeah.
Long story short, I was with the Division of Enforcement of the CFTC in about 6 weeks.
Wow.
It was fantastic. First of all, I always had wanted to be a litigator, and it allowed me to do litigation in the Division of Enforcement. And second of all, I got to do market integrity cases. I got to investigate market integrity cases. I got to bring market integrity cases. And so I learned a lot about the markets. The one problem I had at the CFTC, when I joined the CFTC, there was really no one. I joined in the New York office. There was no one in the New York office who could train me. So I had to train myself, which I didn't mind. And what I did to learn about the markets was I went to the floor of the commodity exchange and I stationed myself right outside the gold futures trading day. And I literally would watch everything that was going on.
Wow.
And figured by osmosis I'd learned something. Unfortunately, it was such chaos. If you've seen the movie Trading Places, you know that. If you haven't seen the movie Trading Places, I recommend highly that you see it so that you learn about the futures markets in the early 1980s. But anyway, make a long story short, there was a gentleman, his name was George Giro, who was a local on the floor. And he came up to me. I had a big red badge that said CFTC with the scarlet letter. By just having a horse.
Oh yeah, I can imagine.
Everybody knew who I was because I had been with this big badge. But George came up to me and he said, "You look very industrious." He says, "I don't know if I should be talking to you, but if I'm allowed to, I don't mind. Do you know what you're looking at?" I says, "No." He said, "Well, I don't mind helping you understand what you're looking at." He says, "Every day I'll give you a little tip about look at something to help you learn." And he was great. He was a man of his word. And literally every day he'd come over, he'd say, "Don't look at the whole pit. Look at one or two or three traders." And then he would say, "Don't look at the whole body of the traders. Look at their hands. Look at their hand signals." And he really broke it down to micro aspect. I really got to understand how the market worked. I really got to have develop theories about how markets work, how markets are subdivided in the old days with pits, because it got so noisy and so chaotic. Effectively, one market composed of lots of different sub-markets just because of the ability of folks to talk to each other. And then over time, I got to see developments in the market, which was fascinating. In the beginning, everything was, people were running back and forth to deliver order tickets to the people in the ring, absolute chaos. But over time, it started changing. People started using headsets. People started trading options. They started bringing computer paper printouts into the pits to help them understand better the gamut, all the different Greeks associated with options. And at every incident, there was opposition. The world is going to end. You can't let people bring computer paper onto the floor. You can't allow people to use headsets. And then
what was the justification? That it was cheating or unfair or what?
Because they had it and I didn't have it. It was nothing more than they had the fancy toy and I didn't have the fancy toy. And they were making more money than me now with a fancy toy.
Yeah.
And then I got to start seeing progression to electronic trading. That was a showstopper. Because ultimately, as we now know, almost all trading is electronic. But I got to see the evolution of trading from early stages where it was just yelling and screaming and passing paper to electronic, appliances around the pit, headsets, technology that allow people to better trade, into seeing the whole of electronification of markets, and that was just an amazing thing. So
I was about to say, this kind of, I think a theme of this podcast is history doesn't repeat, but it rhymes. And when you describe this evolution of traders adopting technology and moving to a new format and a new kind of venue, it makes me think of sports bettors today. Sports bettors who are used to betting against the sports book and having to do all the things that you need to do to be a successful sports bettor in that industry, to now prediction markets kind of shaking things up. Now you can make a resting order. Now you can be the maker if you want. Now you can book the other side of parlays. And I'm just wondering, high level, I didn't realize until now that you were actually in the pit, witnessing this, seeing the whites of their eyes. And I want to ask you, of the traders that were able to, what were the characteristics of the traders who were able to adapt and able to survive the transformation, and the characteristics of those who didn't? And what did you notice? And do you have any kind of I don't know, maybe advice for someone who's also going through a similar transformation at the moment?
Well, absolutely. I mean, the key is open-mindedness. Mm-hmm. And the key is basically be willing to accept new ideas. I mean, even as I was joining the Commodity Futures Trading Commission, there was no such thing. I mean, the use of laptop computers by folks like me, lawyers, was very, very uncommon. I was fortunate, an undergraduate, and while I was studying for my MBA, just for fun, I took courses in computer science. So I had a sense of how to do programming. And when I joined the commission, I had my own personal PC that I had bought because I was fascinated. And I learned how to develop macros on what was the predecessor of Excel, which is Lotus 123. And I used those macros to help me do analytics. Well, the same thing with the guys on the floor. The folks who were able to adapt and start using computer technology, start exploring and taking advantage of the new technology because they were open-minded, they were the guys who and gals who were the most successful. When I started, there was no such thing as high-frequency trading. It was, as low-frequency trading as it could be. And I got to see the development of proprietary trading firms who used math and computers to help develop their trading skills. And yes, they did better typically than folks who didn't have those skills. But they simply took advantage. They were open-minded to technology, and they were open-minded to, evolution. We're seeing that now. Folks who are open-minded to artificial intelligence clearly have a leg up, I believe, over people who aren't open-minded to AI. Going forward, folks who are open-minded about exploring the use of quantum computing will be much better off than the folks who don't. I mean, again, it scares some people, but the people who get over their fear and embrace it are very, very helpful. And as you said, you have seen that. The big debate right now is classic betting, okay, which is, the house always, basically is the winner, versus all of a sudden now folks are getting to do these kind of contracts against other traders. And maybe there's commissions, maybe there's some amount that the house is taking, but they're not typically the counterparties. Certainly, when as we talk later on, prediction markets are regulated markets overseen by the CFTC.
So you joined the CFTC back in it sounds like the early or mid '80s, and I was wondering.
1982.
Yeah, 1982. I was wondering, what from 1982 onwards, what is an example of like a new product? So we talked about technology changing the act of trading. What about the actual underlying? Was an example of a new underlying that came out that like caused a lot of ruckus, or like people were like, this is gambling, or this is crazy, how can we do this? This is not what the CFTC was originally created to do. And can you just tell me, what was an example of that product? What was the timeline of like how people kind of got used to it? And then what like got people around to the idea that actually this product should exist, and actually this is actually very important to exist and is going to help the world in the way that exists?
Well, unfortunately, I may be old, but I'm not that old. The biggest evolution occurred going into 1974, which was the year that the CFTC was effectively created by the Commodity Futures Trading Commission Act of 1974. What had happened was that for many, many years, the CFTC predecessor, the Commodity Exchange Authority, had jurisdiction over what were basically trading on regulated markets on some enumerated contracts. The enumerated contracts were your traditional agricultural products and your traditional livestock products, your wheat, your grain, your pork bellies, etc. What happened was then there began to be interest in trading gold, precious metals. There was interest in trading oil. There was interest in trading foreign exchange. And there was interest in trading a stock index type products. Okay. And that desire to see those products being rationally regulated, just like traditional commodities, that's really what gave rise to the enactment of the CFTC Act in 1974. And then the other thing that happened as part of that is that the CFTC was given exclusive jurisdiction. Exclusive, meaning good, the states were out.
Those two words are very important these days.
We're going to discuss that a lot in the next short while. But the CFTC was given exclusive jurisdiction over, basically futures contracts and options on futures contracts. that were traded on something called a Board of Trade licensed by the CFTC, commonly known as a designated contract market. And that was a very, very big thing, okay? Because now you had, one regulator that was exclusively responsible for these products. Now, interestingly, at the beginning, the states didn't really get the message that Congress wanted to do what we'll later discuss as field exemption in this area. They thought that in order to fulfill the purpose of the Commodity Exchange Act, which is to have rational and well-run markets to allow folks to hedge, okay, you needed to have a single regulator. Well, for the first couple of years of the CFTC's history, they started operation in 1975. It wasn't uncommon for states to try to go after what they considered to be bad doers in the futures market, relying on their bucket shop laws and their gaming statutes. They considered the fact that since most speculators didn't hold futures contracts to the end, but liquidated them before the end, that they were more the nature of gaming contracts. And the courts were actually pretty good about saying, no, that's just not right. CFTC has exclusive jurisdiction. A big case, Payne-Weber versus Conaway in the Northern District of Alabama in, I think it was 1981, very much says gaming statutes don't apply to this business. Bucket shop laws don't apply to the statute. If it's a futures contract, and by the way, later on, and we'll discuss this, if it's a swap and it's traded on a DCM, okay, that's CFTC exclusivity. If it doesn't trade on a DCM, if someone really is doing, nefarious activity, they're not going through the registration process with the CFTC, sure, then the states can rely on their traditional fraud. And even to this day, it's not uncommon to have state and CFTC joint actions with, bucket shops that aren't trading on a designated contract model. But the CFTC was given exclusive jurisdiction. There were challenges. They were rejected by the courts. And then the other thing that was happening at this point in time, late 1970s, early 1980s, was that there were products being developed, futures that were being developed that looked like security. Okay, maybe they were, futures on an index or futures on a single stock security. And so not only was there tension with the states, there was tension with the SEC. And the good news was the then chairpersons of both the CFTC and the SEC, Johnson from the CFTC, Pilger Cry Johnson from the CFTC, and John Shad from the SEC got together and said, okay, we can figure this out. We can figure out when something should be under the CFTC. We can figure out when something should be under the SEC. And they came up with this thing that, depending on whether you're a futures guy or a securities guy, you call the Johnson-Shad Accord or the Shad-Johnson Accord to the same thing, which divided up jurisdiction. They submitted their accord to Congress. Congress basically, amended the Commodity Futures Trading Commission Act or the Commodity Exchange Act as it was, to allow for this accord to go into place. So, again, so we saw the tension with the states, we saw the tension with the SEC, the CFTC prevailed, it goes forward. If Congress ever gets back to their desks, we expect another major advance in CFTC oversight going forward, which is it is likely that the CFTC will receive exclusive jurisdiction over trading of crypto, spot crypto, on licensed exchanges going forward. But again, we need to see it's been proposed under something called the Clarity Act.
Big
see
one.
how that goes, and that's in the future.
So tell me a bit about what your involvement was with crypto, and when crypto started to gain prominence. I had bought 2 Bitcoins when I was a kid. I had to drive to CVS with my new driver's license and MoneyGram or Western Union money to Coinbase to get 2 Bitcoins. man, that was back in $90 each, and I sold them at $100 each. So I was really happy with my $20 profit. But yeah, I just wanted to. It's like it's come so far now, and I feel like you were in the thick of it while crypto was in the throes of trying to be seen as legitimate and try to get regulated and try to be real, right?
Well, yeah. So let me just give you a very quick. I'll tell you how I got there. I was at the CFTC for 4 years, 1982 to 1986. Then I joined a brokerage entity at that time known as Makata Futures Corporation. It later changed its name to Brody White and Company, and then its assets were acquired by a subsidiary of a French bank, Société Générale, known as FEMAT. And basically, I was at Brody White through FEMAT from 1986 through 2012. You know, I
So yeah, I skipped a lot of history there, jumping to crypto.
We're short on time, and I want to discuss
No, it's okay.
event contracts.
But yeah. Well, first, actually, you know, before we get to crypto, like, was there anything? Obviously, crypto is top of mind now, and for most of the people listening to it, that's like what they remember. But I was wondering if there was any kind of product or controversy that happened in those decades where you were working in the derivatives industry that reminds you of crypto and then events contracts, like something that we can look back on.
I would say it wasn't during most of my career until the advent of event contracts. Okay, until the first time I heard about event contracts, which was in 1992. That actually was the first real kind of change, other than swaps. Swaps are relatively new also. So I would say you started seeing folks trading swaps, and you started seeing folks being interested in event contracts in the 90s, and then you ultimately saw laws being enacted to accommodate both products. Certainly by the time the Dodd-Frank law were enacted in 2010. So it was mostly, I would say, technology that was changing. The way the trading changed from when I joined the industry, 1982, to the mid-1990s, and then from that point, you saw, there was actually another change, internationalization. The U.S. had the monopoly in the markets for most of my early career. I think 99% of all transactions occurred on U.S. markets. And then over time, there became internationalization. And in fact, the brokerage company that I joined, as I said, Brody White, it was Makata, Brody White, that became FEMAT. FEMAT became, probably the largest exchange-traded derivatives broker in the world. I mean, I had a boss said he wanted to be the leader up in the international arena. We set up offices all around the world, very, very early on. And we ultimately became, at least initially, in fact, the executing and clearing broker for a lot of our competitors on the international markets, because we were there and they weren't. So that was a big change, seeing trading move all around the world. That was very, very exciting too. But anyway, on my own career path, so when I was at the brokerage, I had all sorts of different positions. At one point, I was even president of Brody White. But most of my career, I was group general counsel. I was responsible for compliance. I was responsible for legal issues. I was responsible for anti-money laundering, which was a developing new area. I left because the parent company wanted to change the organization. I didn't want to be part of a new organization. I set up my own consulting firm for a year. And then what happened was, while I had been in-house counsel, I used a firm called Cahen Rosenman as one of my outside counsel, and I got very, very friendly with the partner there. His name was Adhi. He's one of the legends of the field. And he kept, trying to convince me to join him at Cahen, and I didn't want to join a law firm based on my experience at the beginning. Ultimately, he won, and I joined. The problem was that over the years, I had helped Arthur recruit people to join his law firms. I had a lot of friends working in Cahen. And when I joined, I realized that lawyers get paid, basically, they eat what they kill. You bring in a client, you get paid off that client. And all my friends there were doing the exact same thing that I thought I'd be doing there, which is derivatives, futures, stuff like that. And I said, well, that's not going to be cool because I'm going to steal their business. They're going to get hungry, and I don't want them to get hungry. I'm their friend. So I had to do something else. And I started looking around what field, what practice of law could I do, and I read the Satoshi Nakamoto white paper, and again, because I had that background from my courses in computer science, it made sense. I didn't understand necessarily every technical detail he talked about, but I read it, and I read some ancillary materials about blockchain technology and Bitcoin and ETH. And it really excited me. I sort of said, you know what, this is something I can deal with. And so at that point, maybe a year later, I walked into our general counsel's office, even law firms have general counsels, and I said, I want to develop, a business in crypto. He looked at me askance. Aren't you a little too old for that?
Or especially back then, crypto kind of had this taint of
absolutely.
It's crime, it's whatever,
Oh yeah, my brother worked for the Justice Department, and when I finally told him that I was now doing crypto law, he said, "I can't believe my own brother is helping money launderers." So after Ruth Thanksgiving dinner, but we still stay tight. But anyway, so I started learning more. I started interviewing people who I knew were in the crypto space. One of the guys I talked to was a guy named Paul Chow, who was associated with a firm called Ledger X. And I knew that they were applying with the CFTC to get a license, designated contract market license. And about a year later, he called me up and he said, "Hey, Gary," he said, "you promised me you knew nothing about crypto. You convinced me you were right, and you're not a liar. But you obviously know a lot about derivatives. Can you help me get a license with the CFTC?" And I said yes, and the rest is history, because in about 7-8 months, we got him a license, both as a DCM and a DCO. And the rest,
which, by the way, Kalshi, at its inception, was using Ledger X's DCO. So thank you for making that happen.
You're welcome. And I got to spend a lot of quality time with Chris Giancarlo. During those years. But once I was able to get, with the support of a fantastic bunch of people at Cat and Muchin, they actually did all the work. I believe it or not, I just was a pretty face. But once the word got out that we got them this license, and you can imagine other folks started talking to us, all of a sudden, we were doing all sorts of crypto projects, and they were very, very interested, because I had never thought I'd be giving law in an area where the law was so confusing. People used to say, "Oh, crypto's not regulated." I say, no. Crypto is highly regulated. The problem is the regulation is completely irrational, because there's overlap, there's no exclusive jurisdiction, it's all over the place. And frankly, that really held back the development of the crypto space for years. Is that it was really Russian roulette. Regulators didn't like what you were doing, and a lot of the regulators didn't like it. They thought the world was going to end because of the advent of crypto. They made life miserable for everybody. And so it was really hard to give advice when you had to start saying, well, there's no certainty. This is the best I can do, but I can't guarantee anything. Lawyers aren't used to doing that. But, again, it was, so that was great space. And, we saw development of derivatives in crypto. We saw the CME do Bitcoin futures. We saw, so that was a new asset class also that started developing, and the future will be very, very interesting. Well, I think the developments in crypto are going to be mind-boggling going forward. Not necessarily the same kind of products now, but for example, I think tokenization of real-world assets and securities is going to be a big, big thing going forward. Just like I think stablecoin will be a big, big thing going forward. Bitcoin is sort of substituting for gold in some people's mind as a store of value, and some of these smart contract technology is going to be very, very interesting also.
There's so much that's going to, especially with the more, I would say, friendly regulatory environment towards all this stuff. So much is going to happen. So much is going to get big. But one thing I would love to double click on is
we got to discuss event contracts at some point.
Eventually, because I would really like when the CME started to list crypto products.
Yeah.
What was the process like for them? Because now we kind of people are somewhat aware of like the self-certification process, right? You design a contract, you self-certify it, and then you wait for the CFTC to like say yes or no, and then you go ahead. And so when the CME made that jump to do Bitcoin futures, what went into that? Was it hard? Was it easy? Was there a lot of pushback? Was there not? And like, how did that get smoothed over? And then now you look and it's like doing tons of volume. It's like a huge product. And so just like in a nutshell, like how did that cycle happen where it was like new scary thing to being accepted?
It was a new scary thing. And remember, as you correctly said, prior to 2000, contract markets had to get CFTC's prior approval to list new contracts. And they had to demonstrate something called the economic purpose test, which really meant, the contract has valid hedging purposes and has valid, what they call
price
basic qualities, which means that the prices can be used for reference for other purposes. Then, when the Commodity Futures Modernization Act was signed into law in 2000, a new process began. Again, as you said, self-certification. Basically, I go in there and I say, hey, I'm going to start listing this new contract, and I warrant and represent it that it meets the core principles. And the core principles are about 23 items. Among that is that the contract I'm proposing is not readily susceptible to manipulation. That's critical. And likewise, that there's going to be impartial access to all market participants. I can't give one class of market participants preference over another, and I can't exclude any type of market participant potential. And if we get time, I'll tell you how that came up in one of the political event one of the sports contract cases. So you're absolutely right. That's how it was done. Then, when the CME came in to list Bitcoin futures, and some other exchanges came in to list Bitcoin futures also, the CFTC said, "Wait, hold on a second. We need more time to think about this. We need some, there's special risks with coins. We've got to think about this stuff." So, I don't recall 100%. I sort of remember they came out with some advisory at one point on how to deal with these kind of contracts. But there was definitely more scrutiny given to futures contract in the space. You tended not to just go in with self-certification. You tended to talk to the commission ahead of time. Just to be make sure they were comfortable. They accommodated. I mean, they ultimately accommodated. Obviously, they approved the contracts. But there were bells and whistles that you had to apply that you wouldn't do with a ordinary contract. Because of what we consider to be the special risks around Bitcoin futures.
Gotcha. Well, now it seems like that has all kind of gone out the window a little bit. It seems there isn't much like... Well, Kalshi is often self-certifying a lot of contracts at a rapid clip, to a degree that makes me believe that like not much working with the CFTC before self-certifying is happening, and I don't know. It's like it's an interesting flip towards from what used to happen and now what is kind of the norm now. And we heard like Terry Duffy at the roundtable kind of talk about this a little bit, like, oh, like this shouldn't happen this way. Like you can't just like take advantage of this self-certification in one day kind of thing. And I just find it a very interesting dynamic because, when I look at how this is all set up, like this was always there, right? This was not always, but like since the self-cert process began, there was always this like way you could kind of go for it, right? And now Kalshi's being the one that's like aggressively going for it. And Tarek himself said this at the roundtable that they're, quote unquote, hardcore about their approach to regulation, but at least it's still regulated. And
keep in mind, even under the self-certification route, you still can get you can still request pre-approval from the CFTC if you want. I mean, it's two options. Either you self-certify, and literally you can trade the next day. You can list your product the next day. Or you can ask for pre-approval, and we're going to discuss later on.
For sure. We're 30 minutes in. Oh yeah, absolutely. We're 30 minutes in. We haven't talked about event contracts yet, but I think that's great because this lore is really important. And
I call it the law LAW and the law LOE. Because I'm from Brooklyn, you can't tell the difference.
Exactly.
But
that's so funny. So when did you first hear about event contracts, and like what was the early history of event contracts, and kind of like how did we get here? Now it's like kind of the hot thing.
Well, it's really, so I'm going to describe it very, very quickly, and we've actually touched on some of the points. So the first time I ever heard of an event contract is when I read a no-action letter that was issued by the Division of Trading and Markets, the CFTC, in 1992, to the benefit of the University of Iowa. The University of Iowa had asked for relief. They had somehow correctly assessed that they were developing what they called a market, a political contract market. And the purpose was to determine whether markets can aggregate information and predict election outcomes more accurately than public opinion polling. And so they operated an experimental and for academic purposes this market. It was run by the university and faculty. It was no effort to make money off of the thing. The number of participants were limited. The maximum investment per individual was limited. But they sort of sensed that this thing might be regulated by the CFTC because it had security. Maybe it was a binary option. So it was something that sort of sounded like something under the CFTC. And the CFTC basically said, okay, if you limited it, as you say, because it's really not for profit, and the product really was related to the presidential election in 1992, the Iowa presidential stock market. That's what the market was called. They said you do not have to register as a designated contract. That was in 1992. There was really no big legal analysis around that in the no action letter. It was just like a page or two of the letter. So you didn't really understand what was going on, but that was really the first time I ever heard of an event contract. And then the next year came, and the folks at the Iowa University went back to the CFTC, and they said, you know what, we want to do more. We don't want to limit ourselves just to political contracts. So let's, first of all, we changed our name. We're no longer just the Iowa presidential stock market. We're the Iowa electronic markets. We're still going to have bells and whistles. We're not going to make money. We're going to be good folks, all this kind of stuff. And we still want to offer some political contracts, but we want to deal with different types of elections in 1993 and 1994. But we also want to have contracts on economic indicators, like economic indexes, cross-currency exchange rates. And they also said we want to do a market on earnings, which would be based on the earnings of several corporate stocks. Okay. Well, the CFTC said, okay, we hear what you're doing. You're not changing things radically. We can live with everything you're saying. You can, offer this, limited market, not-for-profit, limited, access, et cetera, et cetera, et cetera. We'll give you no action in connection with what you propose on the political market, and we'll give you no action on what you propose on the economic indicator market, but we can't give you no action on the earnings market because that sounds like options on securities.
Yeah.
If it's based on the earnings of particular securities, that's not within our ambit. We're going to refer that to the SEC and let them decide what they want to do.
And I wonder what they said. Yeah.
You know what? In connection with this, I had sort of recalled that I had never heard of what the SEC did. I did a little research. I couldn't find anything. I couldn't find that the SEC ever responded. The CFTC actually wrote a very good letter to the SEC about this. Saying, you should think about this. And I won't tell you the gentleman it was addressed to. I happen to know the guy. He's a really good guy. But I saw no response officially from the SEC on this matter. So if someone from the SEC at that time was listening to the podcast, call me and tell me if there was ever anything done with it. But anyway, so the market was approved and then reapproved for no action release. They didn't have to register as a designated contract market, and they could offer effectively their predictive markets for political contracts as well as economic indicating. And they did it at least through I gather, in 1994. And we stopped there because then we start seeing some of the laws change that were relevant to event contracts, although not necessarily particular to event contracts at the time. I had mentioned already the Commodity Futures Modernization Act of 2000, which changed the nature of how contracts were approved. And after that all happened, in 2000, the next time I heard about event contracts was 2008. The CFTC issued a concept release on the appropriate treatment of event contracts. It was, again, a very, very thin document. It was published in the Federal Register. And the CFTC basically said, we think that event contracts are maybe within the CFTC's jurisdiction as something called excluded commodities. Now, what's an excluded commodity? So, as I mentioned before, the whole CFTC was set up to be a regulator of a broader spectrum of products, commodities. Well, as part of that, the definition of commodities was a definition of commodity law. And the definition of commodity was really, really broad. I know there's a case down in the Sixth Circuit of Texas that's now challenging this, but at least all of us who've been in the business forever have regarded almost everything as a commodity potential, except for two things: onions and movie tickets, and indexes based on movie tickets. But the definition of commodity is very, very broad. It included, the old enumerated commodities. I told you what those were: grain, corn, live pig bellies, things like that. And then something called excluded commodities. So what are excluded commodities? Well, the definition of excluded commodities is really interesting. It includes an occurrence, extent of an occurrence, or contingency that is beyond the control of the parties to the relevant contract, agreement, or transaction, and associated with a financial, commercial, or economic consequence. So basically, it's a
plain English, please.
Yeah, well, there's no such thing as plain English either. But basically, if you have and there are other excluded commodities too: interest rate futures, exchange rate, all these other kind of things that make sense. But then there's this occurrence, extent of an occurrence, or contingency. Okay. Beyond the control of the parties to the actual contract. So it means that the people who are trading the product can't have an impact on this occurrence, extent or occurrence. And it's associated with a financial, commercial, or economic consequence. So it has to relate to one of those three categories: financial, commercial, or economic consequence. So it's clearly an event contract on whether the CPI is going to go up or down. That's an economic consequence, right? And we'll get into this a little bit later, but to me, if you have a contract based on whether a baseball player is going to, hit above or below 300, I'm not aware of any professional baseball players that work for free. So I do think there's a commercial aspect to that, and if it's right in here, the category of excluded commodity. So anyway, the CFTC issued this concept release in May of 2008 and say, what do you out there in the industries think about event contracts? So again, folks are thinking about event contracts now officially for the first time. And there was lots of response to that. Nothing really happened as a result of that until 2010, 2 years later. And it wasn't that the CFTC then carved out something particular dealing with event contracts. What Congress did is they enacted something called the special rule. And what the CFTC said, and this is really a reflection, on the approval self-certification process.
And this is section 5CC 5C?
Yeah, exactly.
Yeah.
I'm trying to be generic, so not to bore people with the specific.
I'm just trying to impress all my readers that I know.
You've impressed me.
Yeah.
You've impressed me. But so basically, the special rule says that the CFTC may determine that an agreement is contrary to the public interest. And what does that mean? Well, effectively what it says, that something is contrary to the public interest if it involves, if the contract or the transaction involves activity that is unlawful under federal or state law, terrorism, assassination, war, gaming, or other similar activity determined by the Commission by rule or regulation to be contrary to the public interest. But importantly, it didn't say, the special rule wasn't that such contracts would be prohibited. It simply said that the CFTC may determine that such contracts or transactions are contrary to the public interest. And then it says, if it made such a determination, which it didn't have to do, then no trading in such products could occur. Okay, so that's really interesting, because that means that the presumption is that even contracts that have these bad characteristics are okay, unless the CFTC determines they're not okay affirmatively. So that was a big change in the law, and we're going to deal with how that was battered going forward. The other thing that the CFTC did, and remember what brought about Dodd-Frank, it was the financial crisis in 2007, 2008, when it was discovered that we had the banking issues, and then we also discovered that lots of firms were engaging in swap transactions and basically recording them on the back of napkins, if as much as that. And so there was a big effort to better regulate swaps, bring swaps to markets, just like futures contracts were on the markets. And a whole regulatory scheme was added related to swaps. And swaps had a definition now for the first time. Basically, a swap meant a bunch of stuff, including certain types of options. But also, a swap is effectively a transaction that provides for any purchase, sale, payment, or delivery that is dependent on the occurrence, non-occurrence, or the extent of the occurrence of an event or contingency associated with a potential financial, economic, or commercial consequence. Remember we heard that phrase before in the definition of an excluded commodity? Well, now we hear it again. A swap is something that provides for any one of the definitions. There's other parts too, that provide for any purchase, sale, payment, or delivery that is dependent on the occurrence, non-occurrence, or the extent of the occurrence of an event. That word's going to become very critical later on, or contingency associated with potential financial, economic, or commercial consequences. So those are some important changes that occurred by law. About a year later, in 2011, the CFTC adopted a rule to implement that special rule that we just talked about. And
Rule 40.11.
Boy, you're right on top. You're not going to hate it.
I'm the teacher's pet. I have done my homework.
I used to teach derivatives regulation at Brooklyn Law School for about a decade. Yes, you would definitely get an AMI class.
I appreciate that. Can I? So is the direction you're going with this is like especially when you were talking about the word may,
Yeah.
right, earlier. I've heard from... you're not the only lawyer I talk to, believe it or not.
There's so many. We're like top all over the place.
And I've heard kind
By
of
the way,
like...
apologies to my colleagues in this profession.
no,
These guys aren't.
I've heard that there's like this kind of a theory, or maybe it is not a theory or it's real or what, but that Rule 40.11 itself may not be legal. Or
Okay,
like enforceable.
let me jump ahead.
Am I, okay, so, well, how
No, because you're on.
I was the one disrupting class with like my question, but you can like go through the history that you're going to go to and get to that if you want to.
Okay,
Yeah.
so I was going to go and talk about political contracts first, but
Okay.
I'm going to take a slight deviation and talk about the application of ERIS X to list RSBIX NFL futures contracts in 2020. Okay, because what you just said is it feeds right into that. So in December of 2020, ERIS X, which is now part of CBOE Global Markets, self-certified 3 financially settled contracts called as RSBIX NFL futures contract. Pursuant to the special rule, because there was the word, remember, gaming is one of the baddies. On December 23rd, just a few days after they filed, the CFTC advised ERIS-X that it had determined that NFL contracts may involve or relate to gaming and invoke the 90-day rule. So the thing then apparently meandered around the CFTC for a while. And it apparently at some point it was communicated to ERIS-X that the CFTC was going to take advantage of their right to deny the rule, and that word got out. And so a day before the 90-day period expired, ERIS-X ended up withdrawing their self-certification. In response, there were 2 statements issued by 2 of my favorite CFTC commissioners. The one relevant to your point was by Brian Quintez, who unfortunately, as we know, was recently nominated to be chair of the CFTC and ultimately withdrew.
And he famously wrote a memo called Any Given Sunday.
Yeah.
Or not so famously, but yeah.
He was a great writer.
Yeah, I loved it.
And I always chuckled when I read his views, but he was very smart. Mm-hmm. But he actually said the law. First of all, he said the law is unconstitutional. The special rule itself is unconstitutional. Because under the law, the CFTC has unfettered discretion to deny contracts based on a public interest determination, but public interest was not a defined term. And the CFTC was saying informally that, it was, you have to show that, it's valid for hedging, and you had to show it was valid for price basing, but that requirement was eliminated in 2000. Okay, but the CFTC was still applying it because of this special rule. So he felt that the law was unconstitutional on its face for vagueness. He also claimed, to your point, big shot 40.11 was invalid, and he claimed because it reversed the presumption of the law. The law basically said that all contracts, even including all those bad elements, involving those bad elements, were presumptively okay, unless the CFTC said maybe not. Okay.
Yeah.
Okay. So the law said the opposite. The rule that was written said the opposite. It said all these are prohibited. Period.
Yeah, it just used... So this is my understanding of what happened. 5C, C5C writes these things are not allowed. War, assassination, etc., etc. And then it may be blocked. And then 40.11, which is the rule, which is not the law. It's like different. It's something the CFTC can just make,
the CFTC's law.
Yeah, and so then they used the text, they like copied and pasted, or like copied the homework of the 5C, C5C, and then said we're gonna block all these. But that's not what 5C actually said that they could do.
Correct.
Do I have that right? Putting it in
I think you're
layman's
I
terms.
think you're absolutely right, and that's exactly what
Yeah.
Brian said. Brian said that it's a big problem, and the law is unconstitutional, and the rule violates the law. So he was he was he was pretty angry. By the way, Dan Berkovitz, and it was amazing because remember, Brian was nominated by a Republican president. Dan Berkovitz was nominated by a Democrat. He also wrote a statement. His was a little bit more less broad in its point of view. There had been a law for a long time, known as PASPA, P-A-S-P-A, which basically said that states couldn't enact laws that allowed gambling or betting on sports events with exemptions to states that were already permitting it, like Nevada. In 2018, that law was knocked down by the Supreme Court, and so Dan pointed that out in his statement, and he said, "Listen, as far as I'm concerned, because of that, if RSX could show an economic purpose, meaning it has a potential for bona fide hedging, and it has a purpose other than gaming itself, it would not be contrary to public interest." His complaint was RSX didn't do that, but they could have, and that would have made the contract okay. He also said another problem with the RSX proposal was that it barred retail persons. And he said, you can't do that under the core principle. You have to have equal access. That's one of the key core principles. So he also said that I would have probably maybe come out, I don't know.
Can I pause you? Why would they do that? That feels like shooting themselves in the foot. Like, why would they block retail from it? Of course, the retail wants to bet on it. It's the NFL.
You got to talk to the folks over there. But
my guess is that they did it because they thought it would make it more okay, or that the CFTC would be like,
I think they were trying to open it to folks who really could benefit from the contract. Like, for example, the guys who sold hot dogs.
Like Jerry Jones, like the owner of the
Cowboys. To buttress the claim that it was a hedging vehicle. But anyway, my guess is that those are the kind of things that could have been discussed internally. That was the premonition of the commission at the time. But it was interesting that even though there was no official denial order issued in this case, because RSX was their application.
There's two separate comments on it. Yeah,
writing effectively dissents to an order that's not out there.
Wow, that's funny when you put it like that. Yeah, and so they withdrew it, and then so we never got an official. We got the opinions of. Yeah, we got the opinions of two officials. But that's not the same thing as an official decision.
Not at all.
So now, how did we end up here?
Am I allowed to talk about?
We'll cut stuff out if we need to or whatever. We're getting to the good part. Let's
talk about some more action in the political contract space.
Yeah, sure.
Okay, so the next time. So remember, the last thing we heard, we know about the Iowa exchange, and we know that we know that this concept release. We don't hear again about event contracts until 2011. Okay, what happened then?
Nadex,
which you now know is Crypto.com, but it wasn't then.
Yeah.
Nadex self-certified political event contracts in December of 2011, and they were denied approval on April 2nd, 2012. That's a 90-day review. Why? Because according to the CFTC, political event contracts involve gaming and are contrary to the public interest. And they said that the economic purpose test, which again, remember, the way the CFTC applied it, that way was told not necessary in 2000, but they were still doing it in 2012. The economic purpose test calls for evaluation of the contract's utility based on their ability for hedging and price basis. And this is great. The CFTC said because of the unpredictability of the specific economic consequences of an election, means that the political event contract cannot reasonably be expected to be used for hedging purposes. That was the basis to deny NADEC's political event contract. I am personally not aware of any contract out there where you know what the result is going to be in advance. So why they said that, we don't know how elections are going to come out, so therefore what's the use? I mean, it defies expectations. I mean, that's what hedging is all about. You're hedging not because you know with certainty what the markets are going to do. You hedge because you know what you need to do, and so you take a position effectively opposite that in the markets to protect yourself. But here, the fundamental reason why markets exist was used against NADEC to deny their political event contract, which to me makes no sense. That's 2011. That's 2011. We meander forward slowly. Okay, we meander forward slowly to 2014. Then some folks from Australia, our good friends down under, Victoria University of Wellington, requested authorization to operate a not-for-profit market for trading of event contracts accessible by U.S. persons, and they applied for no action relief, just like Iowa University. And they said, our markets are going to be just like Iowa University's. We're only going to trade two sub-markets, political events and economic indicators, and we're making the same kind of representation. We're going to limit the number of traders. We're going to limit the amount of money people can put up. We're going to have limited advertising. We're going to use a third party, this company called Aristotle International, to do our KYC kind of stuff. But effectively, we're just Iowa Exchange all over again. And the CFTC said, okay, we'll buy it. I mean, you're right. It just sounds like Iowa University. God bless you. Go forward. 8 years later, the CFTC says we're withdrawing this no action letter from 8 years earlier, April 4th, 2022. The CFTC says the university is not acting in accordance with the commitments made in the NAL, in the no action letter, and therefore it must liquidate or close out all contracts by February 15, 2023. You go back and look at the no action letter withdrawal, it's very, very bare bones. Like, what did they do wrong, you wonder? Well, interestingly, so did the users. So they immediately filed a suit. As I said, the NAL, the no action letter was withdrawn in August. They filed a lawsuit in September. And they basically say, we want a preliminary injunction against the CFTC, shutting down this market which we're relying on. There's no decision. The court doesn't issue a decision. So the users appeal what they consider to be an effective denial of the request for injunction by the district court, and the CFTC moves to dismiss their appeal. It's denied. Okay. The CFTC then withdraws the withdrawal letter. Okay, so there was the original letter, there's the withdrawal letter, the CFTC withdraws the withdrawal letter and simultaneously provides a new letter that basically says, you're done. We're not, you can't rely on our no action letter. But they do articulate some specific issues. They talk about the fact that the platform is no longer operated by the university, but by this company called Aristotle, which was supposed to just be doing KYC. They talk about the fact that a subsidiary of the University of Melbourne has been receiving compensation from Aristotle. And they talk about that the platform is now listing contracts way outside the scope of the original no action letter. They basically, some contemporary event kind of things, not just economic indicators, not just political stuff.
Yeah, like how many times will Donald Trump tweet this week? Yeah, maybe a political event, but
it may be a political event, probably is. Anyway, so the Court of Appeals now gets their act together, and they enjoined the CFTC from closing the predictive market by February. So this is by the following February. They issue this was in May of 2023, and they issue they issue a full decision a couple of months later in July of 2023. And they basically say that what the CFTC did, even in the withdrawal letter, but with new cancellation terms, is final agency action, and absolutely it's appealable. Okay, so they knock out one of the CFTC's big claims, and they say, by the way, your withdrawal of the withdrawal letter violated a prior order that you couldn't cancel this contract, because effectively you are canceling this contract, even though you're being nice and saying, oh, by the way, University of Wellington, if you want to tell us that you have concerns about what we're doing, let us know. So the court is not very happy about that. And they say that even though the new letter gives lists right to sort of write back to the CFTC and say what you think is wrong, that's not the process you need to follow. When you want to cancel someone's license. And they said effectively, University of Wellington had an effective license to do what they were doing. The CFTC didn't give the university a chance to really rebut what they were charging, nor did they give them a chance to correct what they thought had gone wrong. So what happened after that? Well, long story short, ultimately the CFTC decides not to go forward with their appeal. They get
to settle. Yeah.
Well, they don't really settle. They really just say we're not gonna do this appeal anymore. We drop our appeal. They issue a new no action letter, amending the original no action letter, not the withdrawal of the withdrawal letter.
Yeah. Yeah.
And they allow the entity to operate. They allow Aristotle to be involved. And then in last month, today's October. Yeah. Last month, this facility, known as Predicted now, by the way, it was known as Predicted back then, also received the DCM and DCO license,
which I think is like, what a story, right? Like, you start off with the no action letter and you kind of do your thing for years on multiple election cycles. Then it gets yanked because, and like in Quintenz's own word, according to John Phillips himself, like Quinten said, there's other people trying to do what you're trying to do, and they're implying that the existence of Predicted is making their case stronger, so we want to end Predicted to make their case weaker, right? And to go through all of that and to then now end up with the Holy Grail, the DCM and the DCO combo, it's just like this incredible fall from grace and then rebirth like a phoenix story. At least that's how it feels to me as a nerd. Maybe not to everyone else, but I think it's incredible.
Yeah.
So let's talk about sports. So we touched on it a bit earlier with the Quinten's letter, Any Given Sunday, what ARSX tried to do, and now we're here. In your opinion, one, how did we get here? Just high level. Two, like, what's going on with preemption? What do you think is going to happen? Is it going to go to the Supreme Court? How will the Supreme Court rule? How do you handicap this? I know every time I ask any lawyer to, like, what's your price for this? They're like, I don't gamble, like, whatever, they don't give me a price. And I'm like trying to, if you could be so gracious to handicap what you think will happen. Will it go to the Supreme Court? What will happen in the Supreme Court? And then perhaps, even higher level, like, what this means for event contracts, like, overall. Like, is anything game now?
Sure.
Yeah.
And just for the record, if anybody in the audience wants to know about, the excitement of Polymarket or Calci in connection with political contracts, we can discuss that offline. But those are interesting stories too. Mm-hmm. The sports, first of all, I'm a big believer in the exclusive jurisdiction of the CFTC. As you said, history doesn't repeat, but it sure does rhyme. And I'm not sure that gaming rhymes with gaming. But the history of the CFTC was that it was attacked under the gaming statute. How ironic. Now, what is it? Almost 50 years later, the states are now saying, oh, by the way, you guys need to comply with our gaming statutes. We don't care about CFTC exclusive jurisdiction. We've come full circle. Okay. And, my personal sense will be, that exclusive jurisdiction means something. Okay. Exclusive jurisdiction means something. The problem here is you have a very interesting case now where you've got two opposite decisions in sports contracts by the same judge.
Please explain this to me. How is this possible?
Now,
he just changed his mind, I guess.
I guess he changed his mind. I mean, when the Nevada Gaming Commission went to Calci, the Nevada Gaming Commission went to Calci and said, "Hey, cease and desist with your." By the way, it's not just sporting event contracts, but political event contracts too, because they're gaming, and you better comply with our gaming licensing requirement. The judge did the right analysis, in my view, of preemption. And he basically said, no, CFTC got pretty strong authority. It's pretty clear under the Commodity Exchange Act. It's pretty clear from the debates leading up to the Commodity Exchange Act that the CFTC was meant to have exclusive jurisdiction in this space. Okay? And if the damn contract...
So let me pause you. This space meaning any contract that happens to be traded on a designated contract.
Correct.
A DC.
The CFTC...
They didn't say, Congress didn't say... We want all sports gambling or sports betting to the exclusive jurisdiction.
All futures contract to be.
Yeah,
traded.
Exactly. It's not about what. It's really not about what the thing is. It's about where it's happening. I think this is people are missing the point about this lawsuit, right? And when people, especially, my God, sports gambling Twitter, insane. People are really vitriolic and very hateful towards me just because I guess I'm a torchbearer for prediction markets or whatever.
Because you're a nerd and real.
Yeah, it's they want to put me back in. Actually, this is a total aside, but there was a representative of a tribe who's time to stuff these nerds back in the lockers, and I was my God, this is crazy. But yeah, the point is there's so much the emotional knee-jerk reaction is this is sports betting, this is gambling. States do gambling, so it's but it's not the fact that it's not about sports at all. It's really about
it has nothing to do with sports at all.
Jurisdiction.
But anyway, so Dr. Jekyll and Mr. Hyde.
Yes.
So Dr. Gordon and Mr. Gordon.
Yeah.
Dr. Gordon said preemption reigns when the case was against Calci, or Calci brought the case. When Crypto.com brought the case, he said, "Well, I've had new thoughts." We're not talking about a swap. So therefore, it's not a swap trading on a designated contract market. It's something else. And therefore, the CFTC does not have exclusive jurisdiction because the CFTC's exclusive jurisdiction only goes to futures contracts and swaps that are traded on DCMs, not some other contract. Now, why did he say and by the way, he didn't even think about it. He didn't even address this issue. In the Calci case, but in the Crypto.com case, he did. And why did he say that? Well, again, let's go back to that definition of a swap. A swap is something that provides for any purchase or sale, payment or delivery that is dependent on, listen carefully, occurrence, non-occurrence, or the extent of the occurrence of an event. He said there ain't no events in these sports contracts. Now,
he said some really confusing stuff about the word occurrence.
In fairness, he picked out a couple of a whole bunch of dictionaries, and he said, an event is in old days an archaic definition of an event involves an outcome, but that's an archaic definition, he said. So let's forget about that. The current definition of event, or at least the definition of the event at the time that the CFTC adopted the special rule of the definition of swap, was not something that was not a happening, was not an outcome. Wait, hold on a second. Did you just say
I don't follow.
An archaic definition? Archaic means it used to be. I don't know about a lot of folks, but when I was a kid, okay, I rooted for the Mets. I had no choice. My dad refused to let me root for the Yankees. I had to root for the Mets, okay? And to me, the event was, because the Mets were so bad, I think when they lose 120-something games their first year, it was an event if they won. That was an event. He's telling me that was an event. I didn't want to go see the Mets lose. I want to see the Mets win. That was the event. But he using this bunch of definitions and ignoring what he considered to be an archaic definition of event, saying no event existed. So therefore, since no event existed, and he also claimed that no contingency existed, that because he's saying that Crypto.com didn't even discuss the contingency issue until oral argument, which I don't understand the problem with that. But in any case, he said because of those two things, it's not a swap. Therefore, no exclusive jurisdiction. Therefore, I deny Crypto.com's request for an injunction. And by the way, he says in a footnote, I'm not even going to deal with the second part of that test, which it has to deal with the financial, economic, or commercial consequences. He doesn't even deal with it. Okay, because
that's pretty convenient.
Well, yeah. So we don't have guidance. But again, as I said before, very few MLB players work for free.
Yeah.
I can't think of one.
Yeah.
That's where it is. Ironically, there's sort of 4 decisions out there right now. There's a district court in New Jersey that actually sort of agrees with the first approach of the honorable judge Gordon, and then there's another decision in Maryland that takes a contrary position also, but not because of the swap analysis, but simply saying that historically states have been.
This is the presumption against preemption thing.
Yeah. And therefore, there's no preemption here. There's no field preemption. And since that time, New York has gotten into the fray.
It's getting crazy.
We haven't heard it.
Well, so now, like, let's do what we're all here for, is predicting. Right? Forecasting.
Yeah.
And so, do you think this goes to the Supreme Court?
Yes.
And if it does, what do you think happens?
Very interesting. Because you got Loper Bright out there, which really shows that Congress isn't really keen on agencies determining what their own jurisdiction necessarily is.
So the judges get a lot more say in how to interpret these
everything
things.
Has to be looked
that's
at,
high level. That's what Loper Bright is about.
Everything has to be looked at de novo by the judges.
Yeah.
You don't give what they called Chevron deference to entities anymore. So
Also, de novo means like with fresh eyes or like a fresh look. Yeah.
Again, man, you just went from an A to an A+.
Wow, thank you. You're not. Someone told me like I should consider going to law school. I'm like, no. This is fun. Just blogging about it with no consequences, no tests, no grades.
Yeah.
It's fun.
So the CFTC, so the court will go back to the law, and now we go back into Brian Quinten's land. Is this law unconstitutional? Because on its face, it talks about public interest. It clearly has the idea of public interest has clearly been misapplied by the CFTC since 2000. I think there's a very good chance they knock out the special rule period. Now you're back to clear preemption, and I don't know. It seems pretty clear to me.
Well, hold on. So this is so the special. Well, what does the special rule have to do with preemption? Like the states don't care about 5cc 5c.
They don't.
Right?
They really don't. But I'm just saying in the whole analytics because I doubt. I don't know what's going to be looked at by the Supreme Court. Remember the Kalshi, the Nevada Commission. By the way, Nevada is reconsidering now what was their original Kalshi decision. They've been asked to do, and the Nevada is going after these folks for both. I mean, with Crypto.com, it's just as far as I remember, it's just sports contract. But with Kalshi, it was sports and political events. So, it's hard to imagine, some aspect of the special rule isn't going to go up. I do think the exclusive jurisdiction of the CFTC is pretty clear from the beginning of time. Otherwise, why would there be a CFTC? That's why I'm saying.
Yeah.
The whole reason the CFTC was created and the Commodity Exchange Act was modified in 1974 was to give this exclusive jurisdiction. Now, Judge Gordon does present a good argument. He does say, listen, if event is as broad as you think, okay, if it includes happenings, okay, arguably then, even the betting, without being a swap, constitutes a swap, okay, and therefore should be traded on a designated contract market, and therefore it's just too broad. You know, I'm sympathetic to that, you know, but the opposite is also problematic. You know, so you know, maybe we do have a mess that has to be cleaned up, you know, by more federal legislation. But to me, you know, these event contracts, no matter what their underlying is, if it references, if it's a swap, because it references event, and I believe event has to be looked at broadly, and it relates to something that's commercial, and I do believe sports are commercial, I think it's pretty clear that the exclusive jurisdiction of the CFTC applies today, just like it did when all those states challenged the CFTC exclusive jurisdiction back in the 70s and early 80s.
So have you looked at the I mean, so thank you for your point of view. If you looked at have you looked at like how these justices on the Supreme Court have previously talked about preemption, and like what do you think they're going to think about this example? And actually, Gary, let's pause you for a second. I think this will probably be the last thing we talk when I asked you about what you think the justices think about preemption, what you think it's going to happen in the Supreme Court, but
I'm going to ask about some of the other stuff too, because I do want to talk about some of the recent scandals, how that might impact the world.
Oh, okay, yeah, we can do that too. So
maybe you divide this into two parts.
Yeah, I was thinking maybe I'll do that. I'll figure it out. Don't worry about it. I'll figure that stuff out. So this is your point of view on like how you feel about how exclusive jurisdiction matters. What do you think the Supreme Court will think? Because if you look at the background of the justices, a lot of them have a history of ruling in preemption cases, ruling against the federal government. But my impression of this, after having talked to a lot of lawyers and researched with this, is that like preemption is one of those legal doctrines that where previous rulings on preemption is not necessarily a great predictor of future returns. I mean, future rulings on preemption. So I was wondering, is that much of a signal? What do you think these judges are going to come? Where do you think they're going to come down on this particular issue? And is this one of those times where, look, the law says this, and the justices are going to think this is the law? We can't just overturn, like the CEA, right? So
the issue again, and I hate to sound like a lawyer, but I can't tell you how this review of justice will rule. But let me read you a paragraph. I referenced this case, Payne-Weber, in the Northern District of Alabama case from 1981, where the state of Alabama tried to rely on its gaming statutes to go after something that the CFTC thought they had preemption over, and they talk about the fact that the conference report on the final bill, which is the Commodity Futures Trading Act of 1974, stated that the commission, quote, would preempt the field insofar as futures regulation is concerned. And it goes, although there is no federal interest in whether a state prevents fraudulent commodity transactions, remember I told you, if something is fraudulent and it's off the exchange, the states are free to prosecute it. There unquestionably is a federal interest in whether a state brands commodity transactions as gambling and effectively bars those transactions on federally regulated exchanges. Okay? And we've come full circle. The CFTC was established and the Commodity Exchange Act was enacted in 1974 expressly to sort of get all derivatives, exchange-traded derivatives trading under the CFTC, because that was considered to be in the national interest. It was considered critical, to ensure viable and fair market. So it would be very difficult, I think, for the Supreme Court, looking at the legislative history, the transition of the oversight from the Commodity Exchange Authority to the CFTC, the amendments, the drastic amendments, the clear drafting of this exclusive jurisdiction provision and saying, never mind. They would just...
Yeah, I mean, think about the implications. If the implications of, like, letting the state of Michigan or the state of Texas or the state of New York, like, tell the CFTC what they can and can't do, I mean, so then suddenly you have, like, 50 different CFTCs.
Right. And this is why I was so angry when the CFTC issued that advisory a couple of weeks ago about event contracts, saying, hey, by the way, while we're away and the government is closed, you guys should be thinking about the fact that sports contracts, may be subject to all sorts of problems, and you better have plans for that. I mean, first of all, every exchange has to have plans for all sorts of occurrences. I'm not sure why sports contracts were singled out. I'm not aware that either Kalshi or Crypto.com were ever told by the CFTC you can't list sports contracts. And to me, if the CFTC allowed it, therefore now you're in that special bucket, trading on a DCM, and you're within the exclusive jurisdiction. Okay, so I was very surprised by that note.
My interpretation of that guidance that was issued internally was that, like, hey, there's a chance that a judge might come down and say, okay, Kalshi can't be trading in California anymore. Yeah. Right. And then if that happens, even though they don't necessarily agree with that judge, and that really would be problematic in its own way, the CFTC has a rule where you have to let everyone trade it. But in this case, let's not enforce it because it's not Kalshi's choice to not trade in California. Some judge told them that they can't do that. Yeah. And so I think that was the purpose of the guidance. But, like, it's like also kind of, I agree, it's like have a spine. Like, this is your thing. This is happening under your watch. Why didn't you say anything? But it sounds like they're kind of in this wait and see.
Our view is that sports contracts are permitted. There may be folks out there who disagree. I could have lived with that. I thought the way it was written was very, very passive.
Yeah. But, okay, so then how do you think you mentioned that you wanted to say something about, like, the recent scandals that we've seen in sports betting and how that affects what's happening here.
Yeah, I mean, listen, I think it's very, very interesting now that we have problems with Major League Baseball. We've got, two players, like Cleveland Guardians, that have been suspended because of their participation in events that may have helped folks, who gamble. We have the episode last week involving the National Basketball Association, where a current coach and a current player and a past player, were all, alleged to have been involved in schemes that help gamblers. We have, there was a letter by a bunch of senators, to the CFTC, sort of saying, what's going on here in sports contracts. It's hard to imagine that when the new chairperson of the CFTC, if it is Mike Sellett, steps into his office, the first issue he has to deal with is not crypto, but is these event contracts. Remember, there was supposed to be an open forum this year in April on event contract. It didn't happen. It was canceled before it was ever officially scheduled. The CFTC in 2008 had talked about the need to clarify, 2011 had talked about the need to clarify gaming. And there was all these, obviously controversies going on with the various states. It's hard to imagine that there will not be some kind of activity that it comes out of all these events and relates both to, regular gaming. Hey, listen, just yesterday the NCAA reversed its prior inclination to allow college persons on teams to bet on sports events. It's a lot of stuff coming to a head at this point, and there's going to have to be some kind of resolution, and so we'll see where it is. I think it will be a market-oriented response. I don't think there's bans in play. There may be some more bells and whistles attached to things. I'm cautiously optimistic, but the CFTC is not going to stop these kind of contracts, and they're going to fight their preemption authority. I hope so. But we'll see. But there's a lot of stuff happening that can't be ignored that's going on in the sports betting business. That's putting some shadows on the activity, and it's hard to imagine there won't be some kind of response. But keep in mind, it was the FBI that dealt with the last issue. It was a federal regulator. The problem was considered to be national. Okay, if you start having this done state by state, you're going to lose.
Look, it was the coach in one state and the player in another state, and maybe that's an argument that this should be happening under CFTC.
Already has a prohibition against trading on material non-public information as a result of Dodd-Frank provisions and a rule they adopted. You know the number of that rule? 180.1.
No, you got me. I got that question wrong.
so the CFTC already has an infrastructure to deal with the kind of issues that have emerged in the latest scandals. And, that because there is a comprehensive regulatory scheme dealing with the trading of derivatives based on commodities on platforms. And, to me, that sort of supports why the CFTC should be allowed to regulate this space on a preemptive basis.
Yeah, absolutely. Well, Gary, this has been incredible, super informative and history lesson about what's going on here. I think this kind of thing is so crucial. Having the context, having the expert weigh in is very important to help conceptualize this issue that I think is very emotional for some people and very knee jerk. So I really appreciate you taking the time, and it's been an absolute pleasure.
Yeah. It's been a pleasure to talk to you. I'm sorry we got sort of sort of erratic in our direction at the end.
No, this is great. That's
points.
Absolutely. Yeah, and maybe I'll fix it in post. It's okay.